Ready? Okay, let's go on the record. We are in the 9th Judicial District Court, State of New Mexico, County of Curry. Two cause numbers, D905CR 2022-00200 and D905CR 2024-0029. Both of these matters involve the State of New Mexico versus COLLIN GUTHALS. The defendant is present today. He's with Matthew Chandler. Present for the state is Anthony Jaimez, as well as Quentin Ray. We are set today for a plea hearing, and I note that we have a large group of people with us today. And so just to give you an expectation of how a plea would go, it's going to start with the court addressing Mr. Guthals directly and asking him a series of questions. And then we'll also be able to hear from the state and Mr. Chandler. But there is a portion of this case, the plea hearing, that we're going to jump straight into, which is basically a discussion between the court and Mr. Guthals, and I want everyone to be aware of that. I also am aware that this is a highly emotional case, and so I would just ask that we all do our best to control that. I mean, emotion is expected and normal, but it is part of my job to ensure that we just have a peaceful hearing and can process through everything correctly. And so, Mr. Guthals, I have a plea agreement in front of me, and it's been signed by you. Are you prepared to move forward with this plea at this time?
Yes, sir.
Okay, I'm going to be asking you a series of questions. I'm going to place you under oath. If you'll please raise your right hand. Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth under penalty of law?
Yes, sir.
Thank you. Please have a seat. As mentioned, this plea covers two cases, and this plea calls for, and the cause number ending in 2022-00200, that you admit to violating probation as to count one, a violation of state law. Do you in fact admit to violating probation in this matter, Mr. Guthals?
Yeah. Yes, sir.
Okay. Well, you can remain seated as I ask you these questions. So the sentence in that case is your probation is to be revoked, and you are to receive an unsatisfactory discharge from probation. And so that would conclude your probation case. I'll note for the record that you were on probation. You had approximately 5 months left on that case, and you are receiving an unsatisfactory discharge in that case. Do you understand that?
Yes, sir.
And have you been able to talk with Mr. Chandler about this portion of your plea agreement?
Yes, sir.
Do you have any questions about it from the court at this time?
No, sir.
Okay. Now then, turning our attention to the cause number 2024-0029, this plea agreement would have you plead guilty to count one, leaving the scene of an accident that caused great bodily harm or death, and that is a 4th-degree felony. Do you in fact plead guilty to that count, sir?
Yes, sir.
Okay, and then this plea also calls for you to admit that you are one and the same person who was convicted of possession of a controlled substance in cause number D905CR 2015-00158. And do you in fact admit to that prior felony conviction?
Yes, sir.
And does the state have a supplemental information?
Yes, Your Honor, for my approach.
Yeah, I'll go ahead and receive it at this time. Thank you. I'm receiving from the state a supplemental criminal information, and I'll note for the record that this prior felony conviction that I just talked with Mr. Guthals about is in fact listed. And Mr. Guthals, do you agree that this offense was committed on March 20th, 2015, and you received a conditional discharge on February 5th, 2016?
Yes, sir.
And this plea also would call for you to admit that you are one and the same person if convicted of non-residential burglary, a felony offense, in cause number D905CR 2022-00200, and that offense was committed on November 3rd, 2021, and you were convicted on March 29th, 2023. Do you in fact admit to that prior felony conviction?
Yes, sir.
And again, turning our attention to the supplemental criminal information, that charge is listed. That is also the charge where you were just revoked from probation on. And so this court is going to find for habitual enhancement purposes based upon your admissions today and the supplemental criminal information that has been provided. I'm going to find that you are subject to a 4-year habitual enhancement in this case. You understand that, sir?
Yes, sir.
Okay, so then That would mean that the sentence that you're going to receive for the guilty plea for leaving the scene of an accident is 5.5 years in the Department of Corrections, which includes the 4-year habitual enhancement, with 1.5 years of said sentence unconditionally suspended, and that's going to be followed by 1 year of parole. And so, do you understand that you will be serving 4 years in the Department of Corrections?
Yes, sir.
And do you understand that you will be serving 1 year of parole upon your release?
Yes, sir.
Now, while you're on parole, you're going to have a list of rules you have to follow, and those rules will include that you pay parole costs of not less than $25 nor more than $150 per month. You not associate with anyone who is on probation or parole, or with anyone who the probation office determines is a negative influence. You will be required to submit a DNA specimen and pay a $100 DNA fee. One thing that it's a small thing that's not included in here is there is a $10 court facilities fee that will be part of your judgment in this case as a mandatory fee. Also, there is an agreement as part of this plea agreement that you would turn yourself in directly to the Department of Corrections within 24 hours of the conclusion of today's hearing. Do you understand that?
Yes, sir.
Okay. Do you understand that you are going to be on that 1 year of parole and you will have those rules to follow?
Yes, sir.
Were you able to talk with Mr. Chandler about this portion of your plea related to the leaving the scene of an accident plea agreement?
Yes, sir.
And do you have any questions about it at this time?
No, sir.
Okay. Then as far as additional charges in the probation case, the remaining probation violations, counts 2 through 5, are being dismissed. And in the 2024-0029 case, counts 1 and 3 are being dismissed per this agreement. This plea agreement would call for you to make restitution in this matter, and that is something that you would talk to your parole officer about upon completion of your sentence in the Department of Corrections. Do you understand that this is going to be a felony conviction on your record?
Yes, sir.
All right. Now, I want to make sure that you understand, and I'm going to focus mostly on the case with the leaving the scene of an accident, where you are going to be sentenced to the Department of Corrections. I'm going to be focusing mostly on that because we understand in your probation case you had several months left on probation. You could have been revoked, but that is being unsatisfactory discharged. So the focus of the remainder of what I'm going to be talking about is going to be on the leaving the scene case. Okay, sir?
Yes, sir.
All right. First, I want to make sure you understand that had you gone to trial and been convicted, you could have received a maximum sentence of up to 11 years plus 90 days in the Department of Corrections, followed by 1 year parole and $10,300 in fines. Do you understand that?
Yes, sir.
Do you understand that by pleading guilty today, you are waiving your right to have a jury trial before this court?
Yes, sir.
And you understand that we had a multiple-day jury trial that was scheduled, and you're waiving having that trial by entering into this plea agreement today. Do you understand that?
Yes, sir.
Do you understand that you are waiving your right to the assistance of an attorney at all stages of the proceedings, and to an appointed attorney be furnished free of charge if you cannot afford one?
Yes, sir.
Do you also understand that you are waiving the right to confront the witnesses against you and to cross-examine them as to the truthfulness of their testimony?
Yes, sir.
And do you understand you are waiving your right to present evidence on your own behalf and have the state compel witnesses of your choosing to appear and testify?
Yes, sir.
Do you also understand you are waiving your right to remain silent and be presumed innocent until proven guilty beyond a reasonable doubt?
Yes, sir.
Do you understand you're waiving any defenses you may have had in this case?
Yes, sir.
And do you understand you're waiving any right to an appeal that you may have had unless I sentence you to something illegal today?
Yes, sir.
Okay, as to factual basis, Mr. Hymas?
Your Honor, officers of the Clovis Police Department investigated an incident occurring on December 29th of 2023. It involved a motor vehicle striking a pedestrian at the intersection of 14th and Sycamore. Officers arrived and they found a Matthew Gibbs. He was provided medical attention and was later pronounced dead. When officers returned to the scene, they noticed a fluid trail belonging to a vehicle. They also noticed a headlight belonging to a vehicle. Officers were able to determine the make and general year of the vehicle and were able to locate footage from a nearby house on Walnut that didn't show necessarily the accident, but showed a vehicle that matched that description with a defect on the side. Officers were able to identify the defect as a decal belonging to Guthals Nursery, were able to track the vehicle to the property belonging to Guthals Nursery, where officers later learned that Colin Guthals was residing at the time. Officers also spoke to Colin Guthals as part of their investigation. They learned that he admitted to driving the vehicle at that intersection and admitted to returning to that intersection a couple of different times. He was adamant at that time that he did not know that he hit an individual. He did know that he had hit something, had pulled into an apartment building about a block or two from that intersection where a fuel trail continued to spill, and officers were able to confirm that. As a result of those facts, he was charged with leaving the scene of an accident causing great bodily harm or death. Those are the facts the state would use.
Thank you, Mr. Jaimes. As to the factual basis, Mr. Chandler?
Yeah.
Either way is fine, sir.
Thank you, Judge. With regard to the statement of facts, the position from the defense would be somewhat similar to the position of the state, with additional facts to be presented to the court for the court's consideration. Yes, on December the 29th of that evening, Colin Guthals was involved in the accident that resulted in the death of Mr. Matthew Gibbs. While traveling on 14th Street near the Sycamore intersection, Colin did accidentally strike Mr. Gibbs. Based upon the investigation that was completed by the Clovis Police Department, all indications were that Colin was driving in a manner that was within the laws, within the speed limit. He was not driving reckless, and that Mr. Gibbs was struck accidentally while Mr. Gibbs was in the roadway. Mr. Guthals did not realize that he had struck an individual. Mr. Gibbs was struck on the front right side of the truck that Mr. Guthals was driving. As indicated by the state, Mr. Guthals stopped approximately 1 to 2 blocks on Sycamore, got out of his vehicle, examined what he could potentially see, if anything, on his vehicle, drove around the block and returned back to 14th and Sycamore, where he stayed for a short period of time and did a precursory search from his vehicle. Never got out of his vehicle, but did a precursory search around looking for any type of pedestrian or anything that he could have possibly struck, and did not see anything. Other than the fluid that had been leaking out of his vehicle and what appeared to be a broken headlight from the right front passenger side of Mr. Guthals' truck, there was no debris whatsoever in the vicinity or on the street of Sycamore and 14th. Mr. Guthals drove that vehicle down 14th Street to the place of business, which is approximately 1.5 to 2 miles away, parked the vehicle and began to examine the vehicle. Another employee from the business also examined the vehicle. Based upon the damage in the vehicle, Mr. Guthals felt that it was necessary to return to the area to attempt to see if there was anyone there that needed assistance. Mr. Guthals got into a more operative vehicle with 2 working headlights, returned to the scene, and attempted to locate anyone in the vicinity and did not find anyone, did not see anyone that needed aid. Mr. Guthals then returned back to the place of business. I would note that when he returned to the scene, there was an individual with him, with Mr. Guthals, and there was no indication that person that Mr. Gibbs was in the area. When Mr. Guthals went back to the business, he would later return prior to Mr. Gibbs being discovered by law enforcement or anyone else. Mr. Guthals returned a 3rd time with 2 other individuals and did not locate Mr. Gibbs, did not see Mr. Gibbs. Mr. Guthals he did not return to the shop. He went to a residence where his girlfriend was residing. The following day, he learned buying through social media that there was in fact a pedestrian, and it was Mr. Gibbs that was struck by the vehicle. He was in shock and just kind of sat in basically shock until he had police contact. Once police contacted him, he gave a full statement as to what had occurred leading up to that incident. After he was arrested, he did pass a polygraph examination by a polygrapher that is recognized by the state of New Mexico as an expert. And all of the indications of the polygraph were that he did and was truthful that he did return to the scene 3 times and never was able to locate Mr. Gibbs whatsoever. As this court is aware, he was also charged with tampering with evidence. That has been dismissed. Mr. GUTHALS did not tamper with evidence. He did not attempt to do anything to potentially destroy evidence or remove evidence or anything of that nature. And those would be the statement of facts that we would present, Judge.
Thank you, sir. I do find that there exists a basis in fact for believing the defendant is guilty of the offense charged, and that an independent record for such factual basis has been made here today. Mr. GUTHALS, did anyone force you to enter into this plea agreement?
No, sir.
Did anyone threaten you to enter into it?
No, sir.
Has anyone made you any promises other than the terms of your plea agreement?
No, sir.
And I'll ask that another way. Has anyone made you any promises other than what we've been going over in court today?
No, sir.
And so do you feel like you fully understand your plea agreement today?
Yes, sir.
Have you, prior to coming here today, have you consumed any drugs or alcohol?
No, sir.
Have you consumed anything that may interfere with your ability to understand what's happening?
No, sir.
I'll just ask again. So you're fully aware and you're fully wanting to enter into this plea agreement. Is that correct, sir?
Yes, sir.
I find that the defendant wishes to give up the constitutional rights of which he's been advised. I find that the defendant and prosecutor have entered into a plea agreement and that the defendant understands and consents to its terms. I find that the plea is voluntary and not the result of forced threats or promises other than the plea agreement. I also find that under the circumstances, it is reasonable that the defendant plead guilty. Are there any immigration issues, Mr. Chandler?
No, Your Honor.
Okay, I find there are no immigration issues. Mr. GUTHALS, having made these findings, I am going to ask in your own voice, how do you plead today in cause number ending in 2024-0029, count 2, leaving the scene of an accident?
I plead guilty.
Okay, thank you, sir. Okay, then. Ask the disposition, Mr. Hymas.
Your Honor.
Yes, Mr. Chandler?
Before we get into disposition, would this be a good time to announce the pre-sentence confinement credit?
Yes, we could do that. That'd be fine.
Okay. Mr. GUTHALS has 465 days of pre-sentence confinement credit that would be applied to the 4-year conviction.
Do you stipulate to that, Mr. Hymas?
Yes, Your Honor.
Okay, then as per stipulation, that will be awarded to Mr. GUTHALS. And then we'll also note the fact at this time that you are going to be required to, assuming I accept the plea agreement, you are going to be required to report to the Department of Corrections within 24 hours. I'll just restate that. We've already talked about it, but you understand that, right?
Yes, sir.
Okay, then as to disposition, Mr. Hymas?
Your Honor, the plea's fair and reasonable, and we'd ask the court to accept it.
Okay. As to disposition, Mr. Chandler?
Your Honor, we believe that the plea agreement that's been crafted takes into all of the circumstances and things into consideration that we provided to the court today. We understand that Mr. GUTHALS was facing 11 years and 90 days, large in part to prior felony offenses that were committed years ago, but those are applicable felony offenses under the Habitual Offender Act, and we would ask that the court accept this plea agreement.
Okay, thank you, sir. Mr. Hymas, do you have any statements to present to this court?
I do, Your Honor. I defer to Ms. Johnson.
Okay. Okay, I'm now going to hear statements from members that are here in the courtroom or online. And so I'll just ask if we can hand a microphone to whoever's going to speak if they're in the courtroom. And then I'll just ask whoever's going to speak if you could start by introducing yourself.
Your Honor, may we approach this briefly?
Sure. So before we get into the statements, procedurally, I am going to announce that I am going to accept this plea agreement. So I want anyone who's giving a statement today to understand that this is something that I'm accepting, and that the sentence is going to be as I've announced in court today. I think it's fair that you know that. And so I'm going to conclude that the defendant knowingly, voluntarily, and intelligently pleads guilty today and also admits to the probation violation. And I'm going to accept the plea agreement, and the findings that I made today shall be made part of the record in this case. And so I do hereby find the judge that the defendant has violated a substantial condition of his probation. That probation is hereby revoked with an unsatisfactory discharge. I do hereby find in the judge that the defendant has find and judge guilty the defendant for count 2, leaving the scene of an accident, a 4th-degree felony, and I sentence him in accordance to the plea agreement that we've gone over in great detail today. So having accepted the plea agreement, I think it's only fair that you know that I've done that, and at this time then we'll hear from the speakers. Thank you.
Your Honor, may we reposition so we give the attention to the people that are speaking?
Yes, that'll be just fine. Thank you.
Just for the court's record, I am Patty Johnson. I'm a victim's advocate with the District Attorney's Office. And beside me is Kansas Gibbs. She is the stepmother to Matthew. She asked me to read her statement today.
Okay.
So I'm reading this in behalf of Kansas Gibbs. On December 29th, 2023, Matthew Gibbs, 24 years old, suffered a tragedy that ultimately changed our family's world. COLLIN GUTHALS hit Matthew with the vehicle that he was driving, leaving Matthew, our son, to die. There were no calls to rescue him, no calls to say that Matthew had been injured, not for at least 2 hours. Matthew lay in the open field dying, when finally someone noticed him and called for help. Matthew never knew a stranger. He had a very loving heart. To add to that, he was autistic, but he never let that slow him down or let that stop him from having the desire to be independent to his capacity. He had been working for merely a year and had put down a deposit for his first apartment. He was excited to start living alone and even bought a scooter for his transportation. We all were so very proud of him. All of this was stripped away, and we were left with the shell of life because of Guthals' actions. Matthew suffered a great deal and was fighting for his life, which was permanently taken. We later learned that the injuries were so extensive that saving his life was not going to be easy. He was stripped from any kind of hope, for he died just moments after ending up at the hospital. The goodbyes and love were taken, and that is something that we will never get back because of Guthals' action. There seems to be no remorse for Guthals' actions. I still wonder how someone lives their life knowing that someone was killed by their own doing. COLLIN, I wonder how you sleep at night, get up the next morning to interact with your family and friends. You were still able to have connections with your life. Sometimes you look from our family and friends. The holidays, the birthdays, the loving family get-togethers you took. All Matthew wanted to do was live the best life that he could. Yet that was taken from him the moment that you hit him with a vehicle. You had no right to be driving in the first place. I often wonder what your thoughts were the moment you took our son's life. How can you not know what you had done? How can you sleep after a small glance, assuming it was not a man that you hit? I am not above knowing and understanding that an accident is just that, but this was not an accident. If you had at least tried to help, that would be one thing, but you failed in the second when you decided his life was not important. That was one of the times that you failed to help Matthew. You had done that. Had you done that, we would not be discussing your innocence. We should settle on the sentence for taking Matthew's life. I am not in agreement with the sentencing, yet at this moment, I feel there will never be enough punishment that would compare to losing Matthew's life, that you were left dying. If he were there at this very moment, he would probably not commend you, and in some way he would also forgive you. That was how sweet, compassionate, and loving he was. But it is not him living this nightmare. There must be punishment for some way that you've done to our family. The thing is, Collin, is you've also hurt your own family. The Guthals name has been tarnished, and you were the one at fault for that. In some way, they are losing you too. Yet you get to live, and one day you will be reunited with your family.
Thank you.
And I believe Matthew's mother is online, and she also has a statement to read.
Okay, so could Matthew's mother, who's online, please identify yourself, and we'll make sure that we can hear you in the courtroom.
Hi, my name is Andrea Hope. I'm the biological mother of Matthew Gibbs.
Okay, thank you so much, and I can hear you clearly, and you may proceed.
I have 3 statements total. One from a Dr. Joan Acari, who is my mother, Matthew's grandmother. One from a Kenneth Hope, who is my husband and Matthew's stepdad, and then one of my own. I will read my mother's first. My name is Joan Acari. I'm writing this statement not as Matthew's grandmother, but also as a special educator that observed Matthew as he grew and developed into a man. I have a BA in special education and elementary education, 2 master's degrees, one in special education and another in administration. My PhD is in educational leadership from NMSU. I retired from NMU in 2017 as a professor in leadership. We knew when Matthew was born, he was different. He was diagnosed with being on the autism spectrum, which caused many in education and medical community to see him differently than other children his age. Matthew also was bent over considerably from a birth defect. Matthew had surgery in his teen years to correct some of the scoliosis. The surgery straightened him up considerably. The surgery was extensive and very painful, but he endured. When his IEPs said that he would not do something, he proved that he could do those things. He learned how to adjust and live with his disability. He almost always had a smile on his face. He was one of the most kind individuals you would have ever met. As he developed into adulthood, he worked hard and was ready to move into his own apartment the Monday after he was killed. When Collin left Matthew to die on a pile of dirt alongside the road, he left a grandson, a son, and a sibling. What I do not understand is why Collin did not render aid. How many times do you have to return to the site to know you have hit and killed someone? There is no excuse for not rendering aid. I am disappointed with our judiciary. The charges for Collin are nowhere near what they should have been. It is one thing to hit someone with an automobile, but another thing to not report the incident and render aid. When you repeatedly turned to the side of the accident, you made a decision to take Matthew's life. When you had someone order the parts to repair the trucks you hit Matthew with, it became a cover-up. You are a grown man who has not learned to make good and proper choices. You have a history of not following the law. May God have mercy on your soul. I forgive you. Next, I will read one from Kenneth Hope, who is Matthew's stepdad. Let me just change my screen real quick. Good morning, Your Honor. I just want to thank you for the opportunity to talk in your courtroom on this day, April 14th, 2025. I am Kenneth Hogue. My son was Matthew Gibbs. I've been married to my beautiful wife, Andrea Hogue, for almost 10 years on July 24th, 2015. She told me I have 5 children. I said, that's so beautiful. I was single, no children, to 5 overnight. She told me they are our children. I'll always have my children, my Candace, my Matthew, my DJ, my Brandon, and my Cheyenne. There will always be challenges and problems, but together as a family, we will unite with love. When I found out from my Andrea of Matthew's passing, I was at work. My son DJ called his mom, and I called in my wife. She was hysterical, but said they killed Matthew. My heart was broken. Because 4 years ago I lost my brother, and now 2 years ago I lost Matthew. I would like to share my personal quote. The actions we make today will be the reflections of tomorrow. The life we know is a miracle we live. I know that my heart is in pain and destroyed, but I drive every day in my car with an autistic license plate with 4 fours. And it reminds me of my son Matthew, and that he is watching over us with love. Colin, you might have took my son, but you will never take the love that he left with us. My son, I will always love you till we see you again. Pop. Lastly, I will read a statement of my own, as Andrea Hope. Good morning, Your Honor. I wish none of us were here this morning. I can't even begin to tell you what our Colin did for me on December 9th. With his lack of responsibility and concern for another. No parent would ever bury a child. It's just not how it should be. It has affected me, my family, loved ones, friends, and the community far more than I could ever express in here today. One day, Colin will walk out of prison to live life as he wishes. But he has given me a life sentence of missing my son forever. Matthew grew up in a home with 4 siblings. He was the second born and my first boy. He grew up with me and his father. Matthew was loved and brought laughter to our family. Matthew's life was anything but easy. When he was a baby, he suffered from GERD and illness. In school, he met bullies and people who were not like him, who judged him and didn't take the time to get to know him. In Matthew's life, we sometimes adjusted things for Matthew to make them easier on him with his autism. But for much of his life, he was raised just like his other 4 siblings, and he learned to make adjustments. I watched him overcome bullies, bad days in school, frustrations, and more. I was there when Matthew had back surgery, and how he laid motionless in bed for days as they could wait to pull his body straight. Then he underwent a very long back surgery, which to our surprise the surgeon was able to do better than he had thought and straightened Matthew back up. This gave Matthew a new sense of confidence in his love for theater. He did amazing in it and even graduated high school, even though some told us he never would. He overcame. He even overcame as an adult and was 1 week from moving into his own apartment. I was so proud of him. The thing that hurts the most to Colin's soul was my goodbye to my son. He's cost me 125 pounds, which I can thank him for, but also has not been good for me in some ways. My overall health has took a hit since that December day. I now find myself needing walkers to get around in a wheelchair, and a nurse aide that comes in my home to help with anything I need. My anxiety now is too much most days. I'm medicated for it. And when that medication is not enough, there's yet another one. I am now tachycardic with my heart beating too fast, and yet another medication for that. It took my peace away. Colin caused great pain in my family. Matthew's siblings are in pain and angry. It breaks my heart as I watch them maneuver through this world that is so cruel and has been made crueler by the death of their brother. I've had to watch and hear the pain of my young grandson, who lost an uncle that he loved. I can only now give him a photo of himself with his uncle, sharing stories of what they did together. I may never know the full impact of what Colin did and how it's affecting my grandson. Your Honor, as we have been going through this difficult time with court, I've had many people speak to me and show support and share their thoughts. I have learned this is not Colin's first time in showing a lack of responsibility, but it stems all the way back into his juvenile years. Colin has made a mockery of the court, lawyers, and probation. You all have been confident to say things need to change, and the judicial system does not even start to touch on how we feel in much of the community. Throughout the ordeal, I've cried to my God. I have asked him not to let this change my heart, and not let me become unforgiving and bitter. But I know in saying this, it's already changed, probably in more ways than I realized. I have not forgiven Colin for what he did, but I'm working on it, and I know forgiveness will help me the most. I told my family after the wreck that this is going to change the trajectory of several people's lives, not knowing just how many lives Matthew would touch even after his death. There are many questions we have as Matthew's family of what happened that night. And we know we will never get them. As God and Colin only know the answers. And that's hard on a mama's heart.